Welcome to Loud Little Ducky. I am Ducky, of course, just unfortunately the face of this channel. And we started off yesterday with breaking down Karmelo Anthony's motion for a new trial by his new appellate attorneys who are pro bono. And so we are going to continue breaking it down. It is a 193 page motion. I think to page 63 is actually the motion itself, and then the rest of them are exhibits, mostly transcripts of judge interviews, which we can watch the videos on instead of reading the transcripts to make it go quicker. But this motion could have been a lot less pages, in my opinion, and you could have still gotten the same point across. I don't know that this is going to work in the state court, where it might work in an appeals court, but a lot of it is just repeating the same thing. So let's get into it again. All right. Also, while you're coming in, don't forget to hit that like button, comment if you're on replay crew, participate in the chat if you would like, subscribe, turn the notification bells on so that my sporadic videos you will be notified of. I also post on Twitter every time I'm going to go live at Loud Little Ducky. And I have recently started posting on TikTok and Instagram, both as well at Loud Little Ducky. So you can follow me on all those places. We also have memberships if you would like to join as well. So we started off yesterday, and we got to page like 1 or 20, 21 or whatever. And I said I wasn't going to necessarily finish repeating everything he wanted to say, because he was just citing all these cases and talking about, the Court of Appeals have said public trial, public trial, public trial. And he's citing all the cases. I will link this in the description box if anybody wants to read some pages that I might skip over, because I get the point. And like I said, I don't necessarily fully disagree about wanting courts to be more public. I just don't know that it violated any constitutional rights the way certain things were done, as far as how much room was available in the trial. Whereas I don't know with the whole things weren't on a public docket type thing. So I would be more than happy that if the Texas appellate court or the U.S. Supreme Court was like, absolutely not, you need to have things more public in Texas, because as a Texas girl, I would love that. But now he has his little spreadsheet here, and he's going to go through some of these cases that he cited. Waller v. Georgia. Overflow room or live feed remote available? No. The entire suppression hearing was closed. No alternative offered. Outcome: closure unjustified. New suppression hearing ordered. Stedman versus State, Texas criminal appellate case of 2012. There was no overflow room or live remote feed available. Family was barred from voir dire for lack of room. Alternatives not considered. That's different than what we have here. Same with Waller in Georgia, which that's a Georgia case, not a Texas case. So it might not have that much standing here, where it wasn't closed. But the outcome of Stedman v. State, structural error, conviction reversed, and new trial ordered. That was because family was barred. Family was not barred in this. Lilly v. State, no trial. There was no overflow room or live feed. Trial conducted in a restricted access setting. Structural error and a new trial. Now, in Lilly v. State, the problem was that they held like the court in like a prison chapel type thing. And it was kind of closed off and stuff, which seems very different here, where a Texas court, said, yeah, it's a violation, but it was a harmless violation. And then the U.S. Appeals Court said, no, it needed to be a new trial, and it was not a harmless error. It was a structural error. Presley v. Georgia, of course, no live video feed, no overflow room. There were reserved rows, overflow not considered. And this one, they reversed. Trial court must consider reasonable alternatives. And so let's see what the deal was in that one. I meant to look that one up. The only spectator who was that one, during the jury selection process, the trial court excluded the only spectator, who was Presley's uncle, from the courtroom. The court cited a lack of space and the potential for intermingling with prospective jurors. And that's with, they left out people for the public trial. This one wasn't this wasn't like a closed fully trial, but I am interested to see what the appeals court has to say about it. Williams v. State, yes, live video feed to a neighboring courtroom. Trivial closure, no violation. Zorns v. Bolin, yes, remote viewing from an observation room. Trivial closure, no violation. This case provided during jury selection, then withdrawn for testimony, no feed thereafter. And he says that it falls on the Waller-Stedman-Lilly side of the line. So we shall see. Are the courts going to find an error with it? So then he goes to talk about more of the cases that he just cited. And then we get to, sadly, this goes on from page 13 to, I believe, 48, where he continues to talk about this public trial. He brings up the fact that the trial of Derek Chauvin, in courtroom cameras were permitted. The entire trial broadcast and live streamed in audio and visual. The state's overflow only proposed was rejected as inadequate, and the public was contemporaneously informed. Amber Geiger, which was a Dallas one, there were courtroom cameras. The whole officer murder trial live streamed from the courtroom and carried live by local stations, and it kept the public informed. Uvalde Gonzalez case, which just happened in 2026, gavel to gavel live stream, a designated media room, and overflow space during jury selection, and the public was informed. New York criminal trial, in courtroom cameras were barred overflow room carrying the proceedings on closed circuit television, and the public was informed. United States v. Bankman Fried was barred because of Federal Rules of Criminal Procedure 53. Overflow courtrooms with live video on the 23rd and 24th floors. The public was informed. United States v. Maxwell, barred because of Federal Rules of Criminal Procedure 53. Because that's federal court. No live stream stuff is happening. Nationwide live audio feed plus in-person viewing of the video feed conference at the courthouse, so you could go there. This case, Collin County, cameras permitted if authorized, none used to carry the proceedings. An overflow feed during voir dire only, June 3rd, then withdrawn for testimony starting June 4th. Thereafter, no overflow room, no audio, no video. No continuing access. The overflow feed was withdrawn after jury selection. No audio or video during testimony or punishment phase. Some of those cases were federal, so they're not going to apply the same as here. But yes, there was more access to those. Notice none of those were in like the DFW area. And then he just goes on to talk more and more and more. He loves Waller. The gag order reinforces the need for a hearing and shows the cumulative restriction. Defendant does not seek in this motion to litigate public's or the witness's independent speech right in the abstract. Defendant relies on a gag order because together with access restrictions and record sequestration, it's limited contemporaneous public understanding of the proceeding and underscores why the denial of public access was not harmless, trivial, or curable after the verdict. Because I would like to know about the public docket. That is something I'm interested in seeing. Why it's not more accessible and contemporaneous with the case. Citing more cases. We're almost done to their public trial violations. All right. So then we get to the next part. And the second ground for the new trial is the state's repudiation of the parties' unrecorded agreement limiting character evidence after the defense relied on it, coerced the waiver of the defendant's right to testify, denied him a complete defense, and warrants an evidentiary hearing. Oh, Lord. So after all of that, because what is that? What does that tell me? I mean, they went on for over 30 pages about the first one. So they obviously think that is their biggest appeals or reason for a new trial. And I expect to see it when they file their regular appeal with the Supreme Court. So the agreement and the defense's reliance, which I am wondering if are they just taking this from Karmelo and Karmelo's parents and certain things that he does have access to, or has he talked to Karmelo's attorney from the trial to discuss this? Where is this information coming from? We'll see if he talks about it. The agreement and the defense's reliance. Santabello does not involve an identical procedural setting, but it supplies the governing due process principle when the state induces detrimental reliance on a definite promise and repudiates it after the reliance can no longer be undone. Fundamental fairness is implicated. In Santabello versus New York, which you just said is not an identical procedure setting, so why are you citing if it's not supposedly relevant? The state made a promise the defendant relied upon and then broke it. Through a change of prosecutors and perhaps inadvertently, the court held that the breach could not stand and vacated the judgment, even though the breach may have been unintentional and even though the sentencing judge said the broken promise had not influenced him. That was from 1971. The defense here relied on the parties' understanding through 3 successive phases of trial. Voir dire, the opening statement, and the cross-examination of state's witnesses. The state repudiated, that word is hard for me, apparently. It only when the defense reached its own case at the point where the reliance could no longer be undone. If the inadvertent breach in Santabello required relief, the deliberate mid-trial repudiation here warrants at least the hearing this ground requests. Before and during the trial, the state and defense operated under an unwritten understanding that certain character and extraneous offense evidence would be excluded and would not be offered at trial. In reliance on that understanding, the defense made strategic commitments it could not later retract. It conducted voir dire and the selection of the jury, delivered its opening statements, and cross-examined the state's witnesses, including foregoing questions it would otherwise have pursued concerning the knife, on the assumption that the agreed-upon evidence would not be introduced. The understanding was never reduced to writing or placed on the record. Affidavit of Trial Counsel, Exhibit 10. Okay, so he got this information from trial counsel. So we will look at that. The agreement, by its terms, covered the defendant's own testimony. Every description the lead prosecutor gave defined the understanding by reference to what happened under the tent. And the defendant was himself an eyewitness to those events. The defense, therefore, understood by the plain meaning of the prosecutor's words that the defendant could testify to the incident just as any other eyewitness without opening the door to character, reputation, or extraneous offense evidence. In reliance on the agreement, the defense forbore throughout the state's case from the cross-examination it otherwise would have conducted, declining to confront the state's student witnesses with their own prior statements describing the complaint's aggression, such as the Austin Metcalf was kind of like an aggressive guy on the team. Then he got triggered, and that Austin and Hunter are not going to let you disrespect them. I hate that they put names of minors in here. That if Austin is about to get into a fight, you can tell. And Austin can be a bit aggressive at times. In the same reliance, the defense declined to designate or call its neuropsychology and forensic psychology experts, introduced none of the subjects during voir dire or opening statements, and limited its punishment presentations to 3 pre-agreed questions of the defendant's mother. The state oh my God, I'm gonna have to listen to this again because find another word. You've used this word so much. You've got to change your word up a little bit. Repudiate. reject, renounce, abandon, forswear, give up, deny the truth or validity, refuse to accept or refuse to be associated with, repudiate, the understanding after inducing the defense reliance. When the defense began to present its case in chief, the state asserted for the first time that the defense had opened the door. So as soon as the defense got up, the state said the defense opened the door to the previously excluded evidence through statements in its opening, and it threatened to introduce the character and extraneous offense evidence the understanding was meant to exclude. By then, the defense had already committed to the course it charted in reliance on the understanding. Its voir dire, its opening statement, and its cross-examination of state's witnesses were complete and could not be undone. A party that obtains the benefit of an opponent's reliance on a definite understanding and then repudiates that understanding once the reliance can no longer be withdrawn raises a serious question of fundamental fairness. And then Santabello v. New York, where one party performs in reliance on the other's promise, due process does not permit the promise simply to be disregarded. The prejudice was compounded by the court's response to assess whether the door had been opened. The court engaged in further review and previewing of the evidence, a course the parties' original understanding had not contemplated. See the affidavit of trial counsel. The court itself addressed the understanding and stated that such agreement between the parties would be unenforceable, confirming that the dispute over the alleged understanding was squarely before the court and that the defense claimed reliance could not be vindicated through enforcement on the existing record. Defendant does not, on the record or present record, advance a freestanding claim of prosecutorial misconduct. The existence and terms of the understanding and the circumstance of its repudiation are disputed and require development at a hearing. Repudiation. Like, how many times are you going to use that word? Repudiate. Yes. I'm listening to it too, but I mean, I get it. You know, a big word, right? But is everything have to be this word in every single argument, in every single paragraph? Because I wonder. Let's see here. I wonder if it can count. Okay, I'm on page 50. So they use the word 23 times. It's crazy. When I search repude, it says 23 times. Okay. Understanding after inducing the defense reliance. When the defense began to present its case in chief, the state asserted for the first time. Okay. Okay. The repudiation coerced the defendant's decision not to testify. After the state disclaimed the agreement, the court advised that it knew of no mechanism to enforce the agreement and would rule under rules of evidence alone, and it allowed the defense only about 10 minutes. There's only 10-minute windows for everything. After requiring counsel to preview the entire direct examination with the prosecutor to decide whether the defendant would take the stand, forced to choose between testifying and exposing himself to the very evidence the state had agreed to withhold, or preserving the forbearance the defense had already performed. The defendant elected not to testify. A 180-degree change in the defense strategy that was the direct consequence of the breach of the agreement. A waiver of the fundamental right to testify extracted under those conditions is not the knowing and voluntarily choice the Constitution requires. Citing Rock v. Arkansas. A prosecutorial agreement the defense relied upon is binding and enforceable as matter of due process. Agreements between the state and an accused are enforced as a matter of due process and fundamental fairness, and a court must independently assess such an agreement's efforts on the constitutional rights at stake. What transforms such an understanding from an unenforceable proposal into a binding constitutional significant commitment is the accused's detrimental reliance upon it. Mabry v. Johnson. A proposal of which the accused has not relied is without constitutional significance, while a promise relied upon to the defendant's detriment implicates the due process clause. Santabello. Here, unlike in Mabry, where relief was denied precisely because the accused had not relied on the withdrawn proposal, the defense relied on the parties, understanding continuously and irreversibly through voir dire its opening statement and cross-examination of state witnesses. And finally, in the decision whether the defendant would testify, the reliance is what rendered the understanding binding and its mid-trial repudiation a denial of due process. Nor may the agreement be dismissed as one the state lacked power to make or the court lacked power to recognize. While a grant of transactional immunity requires the approval of the court, a prosecutor needs no such approval to bind the state not to use particular evidence. A prosecutor can engage in binding agreement to refrain from using particular evidence and may bind himself to an agreement for use immunity without court approval. Graham v. State. The parties' understanding was precisely that, a mutual understanding not to introduce the character, reputation, and extraneous offense evidence each side had assembled against the other. It bound the state when it was made, and its enforceability did not depend on whether the trial court believed it possessed a mechanism to enforce. These principles are not confirmed or confined to the plea context. Courts enforced a prosecutor's promise and forbid the state from keeping the benefit of a defendant's reliance while repudiating the promise that induced it, as a matter of fundamental fairness, even where the breach was unintentional and even where the promise bore on the accused's decision whether to testify. repudiate, but I can say repudiate. It's when he starts making all different forms of the repudiation and all that stuff. It's just awful. It's just, and we get it. This attorney's memoir needs to be named Repudiate. All right, so Santabello, Commonwealth v. Crosby. Enforcing an unconstitutional promise relied upon to the detriment of the constitutional right not to testify, Roe v. Griffin. Barring prosecution where the accused cooperated and testified in reliance of a promise of immunity. The state here induced the defense to forego an entire category of evidence and cross-examination, and then once the reliance could not be undone, repudiated the understanding to expose the defendant to the very evidence it agreed to withhold, the per diem of unfairness these decisions condemn. I want to hear other people pronounce that word. The consequence fell on rights of constitutional dimension. The accused has a fundamental right to testify in his own defense, which we know that they do, and present a complete defense. The mid-trial collapse of evidentiary framework on which the defense had built and the resulting threat to expose the defendant to extraneous offense evidence and the understanding had withheld forced the defendant to forego the stand and the defense to abandon a strategy to which it had already committed before the jury. Whatever merits of the parties dispute over the agreement's scope, its effect was to deny the defendant a fair opportunity to present his evidence. An injury that does not turn on which side had the better reading of the agreement. As trial counsel has sworn, the state's breach directly and significantly undermined the defense's ability to present a complete defense. I mean, you could have put him up there even with that shit coming out. You could have also called back those witnesses, even though it's not your job technically to do it. I would like to know what the full story behind this whole promise is. But we will get the other side to this when the state responds to this motion. Because there could be a miscommunication if we had the transcript, but they said that there was no, there's no record of this promise that was supposedly made. So, I mean, even if it was made, could the state come back and say, no, we didn't make that agreement? Yeah. And to me, something that the state would most likely, I'm not saying they did, but to me, I could see the state saying, if you don't open the door to these things, we won't put them in our case in chief, right? Or we won't bring in character evidence in our case in chief. And if that's the thing, well, that's not breaking a promise, because when the defendant gets up, they're not putting it in their case in chief. That would be the defense's case in chief. So I'm wondering if that was maybe the agreement and they just took it as we weren't going to bring it in the entire case, when it was like, in our case we won't bring it, but when it's your case, we're not making that promise. But the state didn't just get up there and put in this evidence during their case in chief. But they didn't agree to just not go into it if Karmelo opened the door about things, or if you asked questions about Austin's character, well, then that does open the door to ask questions about Karmelo's character. Because I know the defense did ask questions about Austin's character to certain witnesses. So that does open the door. So I'm thinking there's some misunderstanding or miscommunication. Could it be exactly what the defense is saying? Yes. This is why you should get shit in writing or get it on the record. Or plan for both if you're a good attorney. And I just spit everywhere. Isn't that lovely? But we'll see what comes out. National standards confirm that such understanding belong on the record and that the state may not weaponize their absence. Professional standards reinforce the same point, an understanding affecting a client's substantial rights that should be placed on the record, and a prosecutor bears both a duty of candor to the court, which, here we love a candor to the court, and a duty to make a clear and complete record. Defendants' claim, however, rest on due process and detrimental reliance, not on those professional standards themselves. See footnote 1, which says see ABA, Criminal Justice Standards for Defense Functions, Standard 4-6.3, Plea Agreements and Other Negotiated Dispositions. ABA Criminal Justice Standards for the Prosecution's Function, Standard 3. 1.4a, heightened duty of candor to the courts, and Standard 3-1.5, duty to make a clear and complete record, including by placing explanations on the record. Well, if you wanted it clear, defense, maybe you should have put it on the record just to make sure before trial that this is the actual agreement, so that it's on the record and the judge hears the state say, yes, that is our understanding. I do think that eventually they're going to go for inefficient assistance of counsel. There remains a basic unfairness in who was made to bear risk of the understanding silence. The understanding was reached among seasoned professionals, experienced prosecutors, and trial counsel, negotiating in the shadow of a court that itself addressed the subject. If lawyers of that experience did not or could not reduce the understanding to writing or a record clear enough to hold the state to it, the defendant, a young man and a recent high school graduate with no training in the law, cannot fairly be charged with having failed to secure what the seasoned professionals around him left unwritten. Oh gosh, that's horrible. Yeah, get rid of those icky bugs. Ooh, 80 degrees. What does 80 degrees feel like? I don't remember. The defense relied on the understanding that the state accepted the benefit of that reliance and then disclaimed the understanding once the silent became useful. A process that asks the least sophisticated participant in the courtroom to absorb the consequences of the most sophisticated participant's failure to make a record is not even-handed process. Due process requires. At the least, the equities demand that the court resolve this dispute on a developed record rather than on the state's after the fact account. And we'll see what happens. I mean, it sounds like they're making an ineffective counsel argument, but not making it at the same time. The understanding, the reliance, and the reputation can be identified with specificity, and they present fact questions for the hearing. The evidence, the understanding withheld was the character, reputation, and extraneous offense evidence each side had assembled against the other. Again, why are we continuing to repeat things you've already said? As to the defendant, the acts itemized in the state's notice of intent to use extraneous offenses, and as to the complaint and his brother, the evidence of violence, bullying, and racially motivated conduct set out in the defense's motion in limine. The parties reached the understanding in a series of meetings and conversations in May of 2026, culminating in a conference with the court on May 21st, 2026. and the defense memorialized it in a motion in limine tendered to the state and the court. In reliance, the defense conducted voir dire, delivered its opening statements, and cross-examined the state witnesses without introducing the withheld evidence, and it shaped its case around the decision to call the defendant to testify. I thought you said it wasn't memorialized, but it is memorialized in motions. Okay. I would like to see these motions. I didn't see you cite those as exhibits. Maybe he doesn't have the exhibits, but he should have gotten them from the trial counsel. Okay. The defense began its case June 6, 2026, and continued it on Monday, June 8th. On the final day of evidence, the state asserted for the first time that the defense had opened the door in the opening statement, and that the understanding had never contemplated a testifying defendant, and the court advised the parties that it had no mechanism to enforce understanding and would rule under the rules of evidence alone. Faced with the repudiation I'm on page 54. Is it really only, there's no way it can be 23 times. Okay. Oh, I said I was on page 54, I believe. Faced with repudiation, the defense abandoned its plan to call defendant and to present certain expert testimony. The state's own conduct then corroborated the understanding it had just denied. At punishment, it called no witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately. So it doesn't sound like the state entered any of the evidence. It didn't enter any character evidence. Where was this promise broken? And why can't you have an expert come up and testify? Was the expert going to talk about the way Karmelo grew up, or like, I don't know what the expert was for. Why couldn't you put up the expert? Because the expert shouldn't have been getting into character evidence, right? Something is just amiss with this for some reason. The state's own conduct then corroborated the understanding it just denied. At punishment, it called no witnesses, blah, blah, blah. Precisely as Mr. Worst Guy had described on May 11th. Mr. Worst Guy was the prosecutor. The agreement would operate, Exhibit 10, a matter the reporter's record will confirm. The state punishment presentation is circumstantial evidence from which the court may infer the parties' shared understanding. At minimum, it is a fact that should be explored at the evidentiary hearing. And the final ledger confirms the asymmetry of the bench. Neither side ever introduced the character evidence the understanding covered. The state's forbearance costed nothing because the defendant's silence never opened any door. While the defense lost the one witness who was necessarily present under the tent in a self-defense case that required his testimony, these facts are disputed and cannot be resolved only through testimony. The thing is, and that's the thing with self-defense cases, is most of the time people are like, your client doesn't your client never has to actually testify in criminal cases, but they almost have to for a self-defense defense. If they're claiming self-defense, they kind of need to hear why it was self-defense. And there was no evidence put on as to that other than arguments made by the attorneys, in which arguments aren't evidence. But in opening, if you're talking about, and the attorney can open the door. If you bring up character evidence about Austin in your opening, the state can then bring in evidence about Karmelo. But they didn't put any of that in when they were presenting their case. In any of the phases, the state never put in character evidence of Karmelo. That's why I think there is a misunderstanding on what was meant by this promise. The agreement was never reduced to writing, embodied in an order, or recited on the record when it was made. But I thought you said there were like motions in limine and stuff. To complete the record, the defense both furnished its own recitation of the agreement in trial counsel's affidavit and requested the state by email date June 25th, 2026, to counsel for the state. Undersigned counsel asked whether there was some type of agreement between the state and the defense regarding extraneous offenses, whether it was not reduced to writing, and if so, for the state to state what you believe the agreement was from the state's perspective, and further inquired about the procedure by which pleadings were delivered to the court but received and not filed, and about any written waivers signed by the defendant or his counsel. June 25th, 2026, email from undersigned counsel to counsel for the state. As of the date of this motion, the state has not provided a responsive factual recitation of the agreement. I don't think they have to. They can just put it in their reply. Yeah, I just don't know what they were doing. I think the purpose of it was just to try not to bring race in it. Like, don't get up here and state that the Metcalfs hate blacks and Karmelo hates whites. Like, let's not do that. Let's not do what social media was doing and making it into a case about something other than a stabbing, which could have just been a push and shove match. An evidentiary hearing is required. The existent terms and repudiation of the understanding and the strategic decisions the defense made in reliance on it are disputed and cannot be determined from any available records. particularly because no reporter's record of the relevant proceeding is available. These matters can be established only at an evidentiary hearing at which trial counsel, and if necessary, the prosecutor may testify. Oh, now you're getting the attorneys up on the stand. Okay. Sure, Jan. Trial counsel's account is set out in the accompanying affidavit and will be presented at the hearing. Defendant accordingly requests an evidentiary hearing to determine the existence and terms of the understanding, the defense's reliance on it, and the circumstances of its repudiation. My least favorite word in the dictionary right now. In summary, even though I repeated myself multiple times, I'm going to summarize here. The grounds and facts supporting a new trial on the second ground are these. The state induced the defense to try its case under an unwritten agreement limiting character and extraneous offense evidence, foregoing cross-examination, witnesses, and its own client's testimony in reliance on that agreement. Well, that just seems dumb in my opinion, but sure. And repudiated the disagreement. Why couldn't you say and then withdrew the agreement after the defense had performed, coercing the involuntary waiver of the defendant's right to testify and denying him the right to present a complete defense? Because the agreement and its repudiation, now they're just trolling me. Just straight up trolling me. Were placed off the record, an evidentiary hearing is required to resolve them. Should the court not find the second ground persuasive, it should next consider the third ground for a new trial. So they're like, if not these two, how about this third one? Yeah, it just repudiated. I would like you to repudiate your use of the word repudiation, repudiated, reputed. Withdraw that word, please, for the love of God. Third ground for new trial. The court's unsupported provocation instruction improperly limited the defendant's right of self-defense. Now, this one being the last one seems to be their weakest argument. You usually put it in order of strongest to weakest. A provocation instruction limits the right of self-defense and may be given only when the evidence supports all three elements. A provoking the difficulty instruction is one of the few charges that can take a defense away from the jury altogether. Properly given, it tells the jury that a defendant who provoked the encounter forfeits the right of self-defense he would otherwise enjoy. Well, the thing is if the jury did not find that Karmelo provoked the fight, they would then believe that he was doing self-defense. If the jury believed that the Metcalfs or Austin provoked the fight, then they would have ruled for Karmelo. So I don't see how this instruction is getting us anywhere, because it talks about if the jury finds that the defendant provoked it. That they forfeit self-defense if they were a provoking party. But the jury also could have found that Karmelo wasn't the provoking party, that Austin was, and then it would have been ruled in his favor. But the jury didn't find that. The jury found that Karmelo Anthony provoked the fight. So I don't think this provoking thing is going anywhere, in my opinion. I'm not a lawyer, though, but that's kind of the way I see it. For that reason, the Court of Criminal Appeals has held that the instruction may be submitted only when the evidence supports each of its three elements, that giving it without the support is error. Here, the instruction was given without the support, and it did to the defendant's self-defense case exactly what an unsupported provocation charge always does. It invited the jury to set the defense aside before weighing it. On a record in which self-defense was the heart of the case, that error was not harmless and it requires a new trial. Almanza v. State. The defendant's defense at trial was self-defense, and the jury was charged on the justified use of deadly force. The court's charge, however, also instructed the jury on provocation, that the defendant forfeited his right of self-defense if he provoked the difficulty. Yeah, if he provoked it. They could have found that he didn't. A provocation or provoking the difficulty instruction is a limitation on, and in some cases, negation of the right of a self-defense, and for that reason, it should rarely be given. It may be submitted only when the evidence supports each of these three elements, and let's see what these three elements are. One, that the defendant did some act or use some words that provoked the attack on him. Check. We've met element one. Two, that the act or words were reasonably calculated to provoke the attack. If you put your hands on me, see what happens. Telling him he has a knife in the backpack and people not believing him. Having your hand in the backpack where you say you have a weapon. Yeah, the act or words were reasonably calculated to provoke the attack. 3, that the act was done or the words were used for the purpose and with the intent that the defendant would have pretext for inflicting harm upon the other. If any one of the three lacks evidentiary support, this instruction must not be given. I think that it was found that it had met all three elements. That an act was done or words were used, and we were told that words were used for this. Touch me and see what happens. What is that not provoking? I think it is. So I think it should have been read. Just because you don't like that provoke is in there and you don't like that provoking throws your self-defense claim out the window doesn't mean it means you should have tried something else for your defense, to be honest. Because I don't see a problem with this wording. But I am just a lowly duck. Yeah, don't touch me. Stop touching me. They put their hands on me. It does. It's like, okay. So I think all three elements were met. Y'all let me know your thoughts and opinions in the comments. The charge here gave such an instruction. It directed the jury that if, keyword, if the defendant immediately before the difficulty did some act, use some language, or both with the intent to produce the occasion to bring on the difficulty and kill Austin Metcalf, and that such conduct was reasonably calculated to and did provoke a difficulty. Yeah, I believe it did. To which Metcalf responded by attacking or appearing about to attack him. Austin shoved him. And that the defendant then killed Austin Metcalf in the pursuant of his original design. Touch me and see what happens. Austin touched him. Karmelo pursued his original design of touch me and see what happens. He showed Austin what happened if you touch him. I don't think that's something hard to understand, but apparently people have difficulty understanding this. The jury would find against the defendant's claim of self-defense. Yeah. If they found this. If they did not find this, then they could vote for your client. It didn't say because defendant provoked him, you have to disregard self-defense. No, it says if you find. And the jury did find. They found the Easter egg when they were hunting. The instruction thus stripped the defendant of self-defense upon a finding that he provoked Metcalf with a preformed intent and original design to kill him. Well, when you stab somebody, the intent to kill, when you stab somebody in the chest, the intent to kill is just there. This is not rocket science. Love the little ducks. The evidence did not support submission of the instruction. Okay. Let's hear you here. Hear you here. Even viewing the evidence in light most favorable to submission of the instruction, the record did not permit a rational finding of the third Smith element. The state may point to evidence that the defendant remained in the area exchanging words with Austin Metcalf, possessed a knife, or took part in the confrontation. Even credited such evidence does not show that the defendant acted or spoke with the purpose and intent to provoke Metcalf's attack as pretext to inflict harm. Provocation requires more than words, presence, poor judgment, or participation in confrontation. It requires evidence of a preformed design to create the occasion for deadly force. What was he planning to do when his hand was on the knife in his backpack then? What was he doing that for? I mean, I see why this is your last argument because this is bullshit. This one I have, I don't have questions about, in my opinion. The public trial stuff, sure. I want to know more about this agreement stuff to see. I think there's a misunderstanding there. But this, I don't think this is going anywhere. The evidence did not support the submission of the instruction. The third Smith element, intent to provoke as pretext to inflict harm, was absent. The charge demanded even more, requiring a finding that the defendant acted with the intent to produce the occasion to bring on the difficulty and kill Austin Metcalf. and that he killed in pursuance of his original design. Well, see what happens was his original design. Says there is no evidence the defendant approached or spoke to Austin Metcalf with a preformed design to kill him under the pretext of self-defense. It doesn't mean his intent was formed by bringing the knife to the track meet. Maybe he always carries a knife with him. And maybe it's not, oh, I'm going to kill Austin this day. It could just be if any motherfucker tries to mess with me, they're going to get it. An intent and premeditation can be within seconds. You intended to do something, which for Karmelo was stab with his knife somebody if they touched him. That was the intent. Just because he didn't say, I will stab you if you touch me, doesn't mean that the intention wasn't there. Yes, definitely needs Isabella Rainey. I feel like he's just been getting pointers from Gingras or Sarah Boone. The evidence raised at most a sudden confrontation in which the defendant used force he believed immediately necessary to protect himself. There is no reasonable person that would believe that they need to stab somebody because they were pushed or pushed. Sorry. Stabbing somebody was not necessary. Nobody had a gun to them or was choking him or anything like that. His life was not in danger. He was not going to have imminent bodily harm. Submitting a provocation instruction on the record was error because it authorized the jury to deny the defendant his right of self-defense, even if he otherwise acted in lawful self-defense. Yeah. But it's all on if the jury believed. The same unsupported provocation theory also tainted the charge, no retreat instruction, which was held the defendant stand his ground protection unless the jury found he did not provoke Austin Metcalf. And in Texas, there is no retreat. You don't have to retreat in Texas. Where people are like, well, he could have just left the tent. Yeah, he could have. But in Texas, you don't have to retreat. They can't say, well, you could have just gone in your house and shut the door and you would have been fine. We don't have to go in our house and shut the door to be fine. We can say, no. And defense, why didn't you? I don't remember if they did, but why didn't you talk about that he doesn't have to retreat in this situation? I don't know if you talked about that and hammered that in your closing. I forget, but you should have hammered this. But you can also provoke a fight, it not be self-defense, and also just not retreat and not have the right to retreat. I mean, you can stand there all day long. Error was harmful and requires a new trial. I don't believe so. And it was preserved. The defendant objected to the submission of the provocation instruction because the error was preserved. Reversal is required upon showing of some harm. Almanza v. State, preserved charge error is assessed in the light of the entire charge, the state of the evidence, the arguments of counsel, and other relevant information. So we at least know he made an objection to this. The harm here is plain. Self-defense was the central contested issue at trial, and the state did not let the erroneous instruction lie. In closing argument, the prosecution affirmatively relied on the provocation instruction, urging the jury to invoke it to deny the defendant his right of self-defense. Well, then the defense needed to get up in their closing and affirmatively talk about why Karmelo didn't provoke this. An instruction that wrongly authorized the jury to set aside the defendant's only defense. Well, sometimes your defense just sucks. And there's not going to be a defense that works because there is no defense to what they did. And that the state pressed in summation caused harm well beyond some harm threshold and requires a new trial. Trial counsel's affidavit establishes that the defense objected to the provocation instruction and that the state relied on the instruction in closing. Well, once it's allowed in, the state can rely on it. The defendant will supplement with the reporter's record when it's available. In summary, the grounds and facts support a new trial on the third ground are these. The trial court submitted a provocation instruction unsupported by the evidence, which improperly withdrew the law of self-defense. The defendant's sole contested defense from the jury's full consideration, and the error was both preserved and harmful. Should the court not find the third ground independently persuasive, should the court not find the third ground independently persuasive, it should grant a new trial in the interest of justice for the reasons stated in the fourth ground. Okay, so that wasn't their weakest argument. This is their weakest argument. Fourth ground for new trial. A new trial should be granted in the interest of justice. Oh, how rich. Finally, in the alternative, the court should grant a new trial in the interest of justice, even where no single ground independently sufficient, their cumulative effect. A trial in which public access was materially restricted during the testimonial phase, mid-trial repudiation of the parties, agreement that coerced the defendant's silence and gutted his self-defense presentation, and an unsupported instruction that narrowed the same defense, deprived the defendant of the fair, open, and adversarial trial the Constitution guarantees. The court retains discretion to grant new trial in the interest of justice where a valid legal basis supports it. And the grounds above supply that basis. Prayer. Wherefore, premises considered, the court restricted the general public to 10-minute daily admission windows, only 10 minutes to consider if he was going to be testifying. You know, Waller requires these things to be public. Alternative for those foreseeably turned away without the finding requires. Defendant Karmelo Anthony therefore respectfully prays that the court set this motion for an evidentiary hearing at which the facts concerning the closure of the courtroom, the delegation of the courtroom access determination to a non-judicial officer, the parties' unrecorded agreement limiting character evidence, and its repudiation and its preservation, and harm facts concerning the unsupported provocation instruction may be developed, grant the motion, set aside the judgment of conviction, and sentence, order a new trial conducted in a courtroom open to the public, enter written findings of fact and conclusions of law in support of its ruling, grant the relief requested in the interest of justice, and such other and further relief to the defendant, which the defendant may justly be entitled to. Respectfully submitted by Russell Wilson II. Michael Ware and Gary Bledsoe, Brooke Cluse or Close, Sean Derdia, Justin Moore. I certify that a true and correct copy of the foregoing was served on Collin County Criminal District Attorney's Office, including counsel of the record for the state on July 6, 2026, through the electronic filing manager or electric recording. Damn it. I'm going to look up this person real quick. That's not what I wanted. Okay, he's not who I was thinking. Okay. Yeah, and this is just the motion for a new trial. There is also a motion for the judge's recusal. So certified that this motion for a new trial and brief in support was presented to the Honorable Judge presiding over the 296th District Judicial District Court on the 6th day of July in accordance with the Texas Rules of Appellate Procedure. Defendant has contemporaneously filed a verified motion to recuse. This presentment is made solely to satisfy Rule 21.6 and does not waive defendant's motion to recuse, does not constitute consent for the respondent judge to hear or rule on the merits of the motion for a new trial, and does not waive defendant's request that an evidentiary hearing or merits ruling occur only after the motion to recuse has been resolved. And then Exhibit 1. Which is the media order regulating trial proceedings, media access, security, and courtroom decorum, which we got to hear all about. And guess what? The judge said that they considered everything in Waller v. Georgia and Shepard v. Maxwell, which Karmelo Anthony's attorney cited to themselves. No cell phones or other electronic devices will be permitted in the courtroom. No talking, gestures, facial expressions, emotional outbursts, or other reactions to testimony, rulings, or proceedings shall be permitted. No reading of a newspaper, books, or other materials unrelated to the proceeding is allowed. No food, drinks, or chewing gum shall be permitted, except as authorized by the court. All persons must be dressed appropriately. Inappropriate business attire, clothing items displaying messages, logos, symbols, or images related to the case or that are otherwise distracting or potentially prejudicial are prohibited. Hats and caps, prohibited. No signs, banners, or demonstrative materials may be brought into or displayed within the courtroom or courthouse. You will be searched. Members of the public and media shall not congregate in the hallways and entryways. They must comply with the directions of court staff, security staff, and law enforcement personnel at all times. Extrajudicial statements or gag order that was signed July 28, 2025 remains in force. It was signed by the judge presiding. Then here's the map. Of restricted area. Which is active. So in the restricted areas, it was not open for the public. Building access zones was the yellow. So here in the yellow, and then the blue is like where traffic comes in, active traffic. And then the gag order that was submitted on July 28th, 2025. Let's see. All parties to this action and their attorneys, witnesses, expert, consultants, agents, and spokesperson, law enforcement personnel, courthouse staff, court staff, and court-appointed officials. So I don't necessarily like the parties. That says the parties. You know what it doesn't say? His family. His family could still talk out. Karmelo Anthony couldn't, and his attorneys couldn't, but neither could the state or anything like that. Neither could like witnesses and people that were going to be a part of it. They couldn't speak about it. It wasn't like it's not an Aaron Spencer gag order, I'll tell you that, where it was like you can't even go to therapy to talk about the case. They didn't want to taint a jury pool by there being so much stuff out about this case. Register of actions. Disposition, which was charge information, which is 6/9/2026, which could be a plea, which was murder, not guilty, disposition, murder, convicted, not guilty plea, or jury verdict, murder confinement to commencement, 35 years, TDC, Department of Corrections, Dale credit, 12 days. So he got credit. Then it goes into all the different things that happened. Those are subpoenas, a bunch of subpoenas. Disclosure of witnesses, defense's subpoenas. Bill, bond discharge, jury charge, notice of appeal. All that stuff. And then, sorry, that was really loud. Payment transactions. Exhibit 3. This is the transcript. So, interview of Honorable John R. Roach, the judge of the 296th Judicial District Court, by WFAA TV Channel 8, aired on June 11, 2026. And then this is the transcript, which let's bring that up. Yeah, it was basically the docket. They didn't apply it to the family. They just applied it to the parties, which was interesting because like in Karen Reed, it was applied to the attorneys, but it wasn't applied to Karen Reed. So let's watch this interview so we don't have to read that. No, that's not the right one. This one is about 20 minutes. I will put it up at a higher speed.
the Collin County Judiciary.
Let's try 1.5 because let's just do that. All right.
To that, I know the answer to that question, but I got to ask it for the record.
100%.
You've been on the bench for some time.
Yep, I've been on the bench for about 20 years.
20 years, and this is the end.
And then 6 months will be in the end.
Did you want to take on this trial?
I wanted the Collin County Judiciary to take on this trial. It was important to me to have somebody from Collin County preside over this Collin County case. So I didn't ask for it. No one. That's not how it works anyway. Yeah. I didn't ask for it, but I was certainly willing to do it because that's my duty.
In your conversations with, I guess it's an administrative judge who goes, I know they go down the list and they say, all right, it's your turn, it's your turn. As they go through all the conflicts of judges that may, potential conflicts, when they come and say, John, this may be yours, your first reaction is?
I'll take it. Every time. I think it's my job. It's my duty. That's what I was elected to do. Yeah. That's the oath that I took. I'm going to do my job.
No consultation with your family? Or?
No.
No. Nope. And where's that come from?
I don't know. I think it's just duty. I think duty, whether that's duty in the Marine Corps or just duty to my family and stuff, I take duty really seriously. And I took this job to perform that duty. And if that's what I had to do, that's what
He said duty. Yes, but they are elected here. We elect our judges.
I have to do.
Did you fully at the time grasp the enormity of that decision and the outside stuff?
I don't know. I think in some ways I did. I think in other ways I didn't. I certainly knew it was a very, very important case within our community. I didn't think I realized the enormity of the social media and the media during the trial.
How long have you been prepping for this trial?
I've been prepping for this trial with the department, with the Collin County system, with the sheriff's office and everybody for about 8 months.
Is that the longest you've ever had to prep?
100%.
Why?
Logistics. One of the critical pieces of this case where we had minors who were testifying. Prior to me getting the case, we had some of those witnesses doxxed and swatted and revealed on social media. I didn't want that to add to the already traumatic event they've been through, and I didn't want them to change their testimony or be uncooperative with people trying to call as witness out of fear. And so my number one duty at that point in time getting the case was to how do we protect those minors who are critical to this case to come and testify.
I'm sure you've already read and
That's part of it. Part of the reason I didn't cover the case so heavily this entire time is because people were getting doxxed, people were getting swatted, people were getting threatened. They were finding out about people's children and putting it out to the internet. There were some of the most vile people that I have seen doing things to people that supported Austin Metcalf. And these minors needed to be kept safe. But what did the appellate attorney just do? Put out those minor names. And I pray that nothing happens to those people. But I know they've already been threatened. I know people have already said that they were going to do horrible things to those people. I mean, there was an incident right after this where a group of Karmelo supporters said that the next white person that they see, they're attacking. And they did. Those 3 people are now arrested and going to be charged with that. It was dangerous to support the victim in this family, which is bonkers.
Know that one of your fellow judges has already been doxxed and swatted and all the things.
I didn't know that.
And still no reluctance from wanting to take it on.
None.
Yeah. The decision to not have cameras or any kind of streaming.
Listen to this.
Period. I was about to say high-profile cases, but that's not it. It's just any case. Realizes the importance of their job, and their job is to be fair to the state and to the defendant, and to protect the people that come before them, and their job, like you did. Anthony.
I think I skipped
into it. Like I told.
Okay. I hate that I lost my place.
Your decision to not have cameras or streaming inside this?
Sort of. I will tell you this. Sometimes I think maybe I should have at least the audio streamed or something.
I hate to have to ask about stuff that emerges on social media, but I have to ask it. And I know you don't know of any of it because you're not on social media.
I'm on it. I mean, I'm an elected official, so I have a Facebook page and stuff. Do I look at it? Do I monitor it? Do I let it impact me? None. Not at all.
So I have to ask, do you have a personal relationship with the Metcalfs?
I wouldn't know Mr. Metcalf prior to this trial if he walked up to me and said hello. I don't know the Metcalfs. I sympathize with the Metcalfs and what they've been through and all, but I don't know them personally. Never have.
So these AI images emerging of you and them at a party or drinking together, all
Never
of
happened.
that.
And that's the problem with social media, isn't it? You can't tell what's true and what's not true. I will tell you, I got some reports of some things that were coming out of this courtroom, and I wondered to myself, were they even in the same courtroom that I was? It's that bad, and I think that's tragic because I think really if you just listen to the case based upon the facts, you'd understand it so much better.
Do you think it reinforced your decision to not have cameras or streaming inside this?
Sort of. I will tell you this. Sometimes I think maybe I should have at least the audio streamed or something so people could hear it. But at the end of the day, I don't think no matter what, people are going to distort whatever happens or whatever they hear into their own agenda. And so what's the point? And again, that noise affects people. It affects the fairness of the trial, the safety of the witnesses, the safety of the jury. And those are my primary concerns, not what social media says. It's not my duty. I don't think it's my job to feed social media or the media stuff. I certainly understand the role that media plays in a case like this, but I'm not here to feed it. And I took that very, very seriously.
But Judge, when people don't have access to the trial or the courtroom, doesn't it invite speculation?
Well, sort of, but I got 70 seats in my courtroom, and I had 200 requests by the media to sit in the courtroom. So let's say if I just entertained the press.
Right. And is this not a huge courthouse? Like, there's just not unlimited seatings in this. I need to go back.
Do I look at it? Do I monitor it? Do I let it impact?
Get from people around you about that decision?
In the courtroom, change the way that.
Or any kind of streaming. Was that an easy one?
Yes.
One of your fellow judges has already been doxxed.
All right, that's what I wanted
at that point in time getting the case was to how do we protect those minors?
This
who
about
are
a
critical to
fellow
this case to come and
judge.
testify.
I'm sure you've already read and know that one of your fellow judges has already been doxxed and swatted and all the things.
I didn't know that.
And
A fellow judge of his was doxxed and swatted already. Yeah, that's not going to allow for certain things. I do think it does put down some of the speculation stuff that happens. I do agree that people are going to distort it into something else because people can look at evidence and actually just not see it. I mean, there could literally be a green sky and they will tell you it's red. They'll tell you the sun is black. No matter how much you show them in their face, because they're just not going to admit to reality.
still no reluctance from wanting to take it off.
None.
Yeah. The decision to not have cameras or any kind of streaming, was that an easy one?
Yes, it was an easy decision. And I'll tell you why. My primary goal in any case is to make sure that the defendant and the prosecution gets a fair trial, period. I've seen from other cases around the country where cameras in the courtroom changed the way that the judge acted, the lawyers acted, some of the witnesses acted, and we were not going to have that here. We were going to really isolate the purpose for which we were here for, which is to have that fair trial, and cameras in the courtroom did not enter into that equation at all.
How much grief did you get from people around you about that decision?
I don't know. I don't listen to it. I just flat don't listen to what's going on the outside. I do what I think is right, no matter what decision that is. And I sleep well at night knowing if I follow the law, then everything works out like it's supposed to. And so these outside influences, all the noise from the outside, I really isolated myself from that in this case and in all cases, and just do my job the best I can following the law.
How do you think we're talking with the attorneys, other attorneys outside of this. How do you think they describe you?
Strict, no nonsense, fair. And that to me is the most important part. I know for a fact when I make a decision here, people are unhappy. But I hope is when they walk out the door that they think they got a fair trial or fair hearing or fair something. And if they do that, no matter what they think about me personally, then I've succeeded. And
you're okay with any of those characterizations?
I think they're fair.
Yeah. I hate to have to ask about stuff that emerges on social media, but I have to ask it. And I know you don't know of any of it because you're not on social media.
I'm on it. I mean, I'm an elected official, so I have a Facebook page and stuff.
Do you have a personal relationship with the Metcalfs?
I wouldn't know Mr. Metcalf prior to this.
Which we saw. There was a picture that was going around that they were like, oh, this is the judge. This judge was not in that picture. It was fake. It was something that people had to stir up and lie about because they can't face the truth.
How trial works. Do you think that this may have been an opportunity for people to know how it truly works, and that kind of erases some of the negative notions of court and trial?
I'm doing this interview with you to make sure that people understand how the system works, and if they really wanted to, and I mean seriously, if they wanted to, they could have stood in line with everybody else, and had the 27 to 32 public seats that we had in this courtroom that we rotated every day. And so, was that important to them? They could have made it in here.
How did you plan for some of the outside noise?
Well, we were certainly playing with the sheriff's office and McKinney Police Department and the Allen Police Department and the Frisco Police Department. So those were talks that we were having 8 months before the trial to ensure the safety of the people out in the parking lots. They certainly had a right to demonstrate and all, and I think we struck a very, very good balance to allow them to do that, at the same time maintaining safety of everybody involved.
Did it affect your day-to-day decisions?
Actually, I didn't. I came in from a different entrance from the courthouse. I didn't come in through the front.
Right. The jury didn't come in through the front where all that nonsense was going on either. Now, you know what, though, if there were people, if the jury did see all those people out there, they would have been like, oh, all these people are wanting justice for Karmelo. There was people out there wanting justice for Austin as well, but they weren't being, well, there was like one or two, but they weren't acting in the way that the Karmelo supporters were. And the judge, for the most part, unless something got really, really crazy, even though to me it's just tacky the way that some of them held themselves, they allowed them to sit out there and say whatever they wanted to say. And nobody stopped them from that. So he didn't step on anybody's First Amendment.
I couldn't hear any noise at all from my office. The jurors were not facing the parking lot, so they didn't see anything or hear anything. And I think we did a marvelous job in isolating them and having them concentrate just on what was going on in this courtroom, which was my instruction from the very, very beginning.
What made this trial different?
I think it started off bad. And it started off bad with the doxing and the swatting of the judge and the parties, the witnesses, and all that stuff. So I think it started off bad, and I'm going to attribute that to social media. And I think social media got it wrong. And it is what it is. I think that's something we have to live with these days. But I think it's my responsibility and other judges' responsibility to make sure, no matter what's going on in social media, that someone can walk in the courthouse and get a fair trial.
Did it make it very different when you realize a lot of your witnesses are young witnesses?
No, look, I've been doing this for 20 years. A lot of the witnesses come in all shapes and sizes and colors and all that. And so that was normal for me. What wasn't normal for me is to have those witnesses be intimidated by things being said on social media, because those young people rely on social media more than I certainly do. And so that sure impacted me, to make sure that they did not change their testimony. They were willing to come in and tell the truth without fear of being doxxed or swatted and stuff. And so I took every precaution that I could, consistent with the law, to make that happen.
I know Steve brought it up too, and I know both sides probably brought it up as well. The AI images of people claiming to be inside this courtroom.
Yeah, that ticked me off a little bit, because if you're going to call yourself the press, and people are going to depend on you to tell them what's going on in this courtroom, you should be telling the truth. And so Mr. Stoller, my public information officer, brought it to my attention that some news outlets were posting photos saying from inside the courtroom. And it wasn't my courtroom. It wasn't the witness. It wasn't their testimony. And that's tragic, because, again, that just breeds the narrative that these people want to cultivate in our community to drive a wedge between us. And
You're right. There's a lot of people out there that do not report truth. Those people live in an echo chamber usually. And I do think that this judge did a wonderful job at protecting these minors. He did everything that he could possibly do legally to protect these kids. Because what you don't want is something bad to happen, and the minors and these witnesses don't want to come forward. Now, to me, these people out here doing things to witnesses and all of that type of stuff, to me, they should be charged with witness intimidation. And there are tons that should be charged with this. Yeah, I don't know why he allowed certain things in the papers about minors. To me, those people should be. I don't know if there was a non-disseminate. Well, I don't know if there was like a non-dissemination of the minors. They're not supposed to be reporting minors' names in the paper, but if they're not minors anymore, but they were at the incident, it's still it just shouldn't matter that stop threatening people's lives because somebody that you want to get away with something, somebody's going to speak against them. Too bad.
I think that's terrible.
Since we're on the topic of image,
Uh-huh.
Can we talk about some of the drawings of
Sure,
you during the sketch?
sure,
What do
absolutely.
you think? What do you think?
My wife would show me a drawing every once in a while of a court case going on. I couldn't figure out who the judge was. And it's all in serious. The sketch artist was awesome. She was very sweet. She was here every day, putting her life's work into those images. Because we didn't have cameras in the courtroom, that's the only visual that anybody got. She did a marvelous job. I think I'm more handsome than what she portrayed overall, but I'll let everybody else figure that out.
Did the jury get it right?
Yeah, they did. You know why? Because they were picked based upon the law. They listened to the facts. They happened here in this very courtroom, and they got a verdict. And so that's the process. And whatever they say, they get it right.
There's going to be a lot of scrutiny of voir dire, and you excused you.
I mean, I don't necessarily always agree with that. He can agree with that if he wants. But he is basically saying that whatever the jury decides is the right decision. Well, that may or may not be true. But I mean, to me, the guilty verdict was definitely right.
Not denied the defense, and the dismissing of 3 jurors who at least identified as African American on their bioforms. What did you make of that moment?
Well, that's not exactly how it works. The defense didn't dismiss them.
I'm sorry, the defense raised an objection.
They raised an objection. Yeah, they raised an objection. Like I told you before, as long as I follow the law, I sleep well at night. And I'm telling you, I follow the law in that case. Did I know what the perception was going to be? Sure. I knew in the back of my mind what the perception was going to be. But I'm not here to satisfy perceptions. I'm not here to satisfy agendas. I'm not here to do any of those things. I'm here to follow the law. And I did it to a T. And I'm proud of that. Very proud of that.
Is this your last big trial?
It's my last big trial. The sad part about it is, I will tell you before I leave at the end of the year, I'll try a couple more murder cases, for example. The parking lot won't be full. The gallery won't be full of people watching the case. But we still have somebody who's died and someone accused of doing the killing. And it won't draw the attention that this case did. And their death is no less tragic than the tragic death of the young man in this case. And so, big trial.
Exactly. But if you want to listen, and this judge was going to retire, I think he said before the Karmelo case or whatever, he decided it. But it wasn't like, oh, he was going to make sure that Karmelo got convicted and then he was done. No, he still has other trials until his retirement date comes up. So it wasn't like it was, oh, let's nail this kid to the cross and then I'm done. But that's the way Karmelo's supporters will have you believe.
I guess from an outsider's perspective and the social media and the media interest in the case. But crime still happens in Collin County, and every single person deserves to have as fair of a trial that Karmelo Anthony had.
What's your take on Karmelo Anthony?
I don't know. I really don't know.
You've had a lot of defendants in your courtroom.
I've had a lot of defendants.
I agree, Razmataz. His family should have had him take that plea deal. I think this judge would have also given him less than 35 years. But those are choices that the defendant and the defense's team made that led him here. The judge didn't sentence him. He wanted the jury to sentence him, so the judge was like, okay, jury, what do you say? They said 35 years. The judge said, okay, this is what you wanted, defense. So there you go. It could have been different with different choices, but that's what this whole case is about, right? If you would have made different choices, we wouldn't be here.
And I talked to Mr. Anthony a couple times because I'm legally required to go over some things with him. He seems like a nice young man who committed a crime, and he understands today more than any day before today the consequences of committing a crime like he did.
Last question.
Yes, sir.
The future of the justice system. What do you think about it when you realize you have all these social media influencers and citizen journalists?
I don't know. I hope that the judges that hear cases period. I was about to say high-profile cases, but that's not it. It's just any case. Realizes the importance of their job, and their job is to be fair to the state and to the defendant, and to protect the people that come before them and make just and right decisions based upon the law. And if we can do that, that's great. The influence of social media, I think, is going to continue to impact our communities everywhere. And I hope that we can rely upon our justice system to weed through the noise and find justice for everybody who comes through our doors.
This is a personal question I wanted to ask you.
Sure.
Do you understand why the legitimate media had to be a pain in your ass?
Legitimate media. There's this guy named Jobin, who I think was probably the worst of all of them. And no, I didn't understand how he could be that way. Look, I absolutely understand the media's role in all this. I mean, it's the First Amendment for a reason. It is absolutely the First Amendment for a reason. But at the same time, a defendant has a right to a fair trial, and the prosecution has a right to a fair trial. That's also in the Constitution. And so you just have to balance all those interests. And I'll honestly say, I think I balanced it well. And I know I made people mad, but I'm not here to make them happy either. I hope that the Metcalfs think that their son got a fair trial in this courtroom, as do I hope that the Anthony family thinks their son got a fair trial in this courtroom. I certainly think he did.
Did you feel the pressure of the other courts not being able to operate too?
They do not think that, Judge. They do not. But I suspect that every defendant that loses a case thinks that everything was unfair.
So, of course, they're independent elected officials. They can operate if they want to.
Yeah, and some of them have.
They have.
Virtually.
They have. We were trying to cut down on the sheriff's duty of transporting back and forth and stuff. And so I asked them if they could modify the way they are operating in court. They could go to Zoom like we did for a long time. They could, pick days that we weren't here, like on that first Tuesday. But it's up to them. It helped a lot that they cooperated. And by the way, that's one of the messages that I don't think I've been saying enough is what we did here was a well-oiled machine. I've never seen a case.
You want that on the record?
Sure.
Okay. You were on.
Hey, the case that we tried here in Collin County was a well-oiled machine. I mean, Collin County, it should be the model for high-profile cases from here on out. And that's because we started 8 months ago, and I met with anybody from facilities to IT to the audiovisual people to the sheriff's office. We constantly came together and met to make sure that Collin County was going to be a focus for a minute. And we wanted to make sure that everybody understood, number one, don't come around and mess with Collin County. And because we're here for a job, that job is to make sure that everybody gets a fair trial and everybody's safe. And we want it to go seamlessly. And one thing that does worry me a little bit is people go, oh, this was a 5-day case with the evidence. A 5-day case, it must have been cut and dry. I don't know if that's true or not. It was 5 days because I wasn't wasting anybody's time. Our community needed to heal quickly. They needed this case over one way or another, but the case had to be fair first. But we accomplished that. But it was a gargantuan effort by every single person involved in Collin County and outside Collin County. And so we're very, very proud of our county, all of our employees, all of our elected officials, all of our judges, everybody in getting this case tried quickly because our community needed it to heal.
Thank you, Judge, for talking with us.
Sure.
So that is the WFAA interview. And I don't know if I would say that Collin County is the model for high-profile trials and things like that, because I do think there is a way to be more open to the public and do the other things that he did. So I would just like to tweak that they allow for the planning for, a long time. And I think every high-profile trial does have to plan and talk to surrounding cities or cities that are in your county and different things like that. But more transparency, I think, is better. But I also get protecting people and to get a fair and just result. Now, let's see here. Okay, the affidavit. So Karmelo Anthony's affidavit of Russell Wilson II authenticating exhibits to defendant's motion for new trial. Lead counsel Same exhibits are offered in support of both defendants' motion for new trial and defendants' verified motion to recuse. Okay. That was the transcript for that. Okay. This is somebody that says, Judge John Roach tells me he released the evidence because I understand the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, witnesses, and jury. Now that the trial over, it is important to me to provide transparency. Which, yes, case files can be given out and more information can be released to the public when things can be unsealed. It happens in all cases. I don't think that's weird. A thank you letter from the judge, okay, to the members of the Collin County family. I want to express my sincere gratitude to the countless individuals and agencies whose professionalism, dedication, and cooperation made it possible for the court to fulfill its most fundamental responsibility, ensuring the fair, orderly, and secure administration of justice. Trials attract significant public attention, require extraordinary preparations behind the scenes. While much of the public focuses is naturally directed towards what occurs inside the courtroom, the truth is that work of the administration justice depends upon the collective efforts of many people, most of whom serve quietly without recognition. Now, he's grateful for the budget department, the IT, human services, the auditors, the CSCD, Public Works, Facilities Department, which responded to challenges professionally, flexible, and willingly. Special thanks to the district clerk's office, the jury service staff. Recognized the sheriff's office, McKinney, Allen, Frisco, and Plano police departments. He talked about that. The fire marshals. Recognize fellow judges of Collin County. The bailiffs. Basically all court staff. And everyone else who played a role, whether through planning meetings, operational communications, all that. The public often sees only the final product. I had the privilege of witnessing countless acts of professionalism and teamwork. Okay, I don't see anything wrong with that, but all right. Sure. I don't think you need a new trial because of that. Let's see. My name is Steve Stoller. This was the public information officer, so the PIO for the Anthony trial. Explain the process that they followed. There are only 70 seats in the courtroom. 15 seats for the prosecution, 15 seats for the family members, 9 seats for the media, including one for the sketch room artist. So that there was actually 8 because, and then add court staff, and that leaves about 24 or so seats. As much as we like turning down people, we had no choice. Yeah, there wasn't any room in that particular court. Collin County Public Information Officer established an application process more than a month before the trial started. Then he left the county. I came in to pick up where he left off. There was a deadline. And they received requests from all over the country from major media outlets, local medias, and a long list of social media influencers. We chose 8 media outlets for credentials on the 21st, so a day after the deadline. We included the local television stations and newspapers who covered Collin County courts on a regular basis. We felt that was the fairest route to take. They invited members who were not approved for credentials to gain access through the general public. Encouraged most of them to get in line early, many of them including some very well-known names in the media world like New York Post, Washington Post, NBC News, waited in the line with the general public. Okay. Credentialing, courtroom access, email correspondence. No overflow for the trial. Okay. Media request intake. So this is what the media could fill out by May 20th. Credentialing process was changed midstream. Applicants were told prior submissions had not transferred. Okay. Let's see. If you're receiving this email because you were previously submitted a request for the media credentials for the upcoming Anthony trial, we are writing to inform you of an important update to our credentialing process. While we previously accepted submissions through Google Form, we have since implemented a new internal system to better manage the process. This message does not confirm your credential approval. Your request is still under review. However, in order to move forward in consideration, we require all applicants, including those who have already submitted, to complete the new form. So you needed to complete the new form. They let you know of this. What day did they let you know of this? April 29th. So you still had almost a month to do this. Nikit at night. This one, she's something. I am reaching out for a quick status update on my media application for Karmelo Anthony, as I finalize my travel and lodging for Nikki at night. I also wanted to ask for the court's latest estimate on the trial's duration. This will help me ensure my logistics are fully secured for the entire proceeding. The courtroom was made available today to local television affiliates solely for the purpose of capturing footage of the empty courtroom for potential use during the upcoming trial. The courtroom is empty during this designated window, and all access was coordinated directly with the bailiffs. Okay, deadline to submit credential requests. Okay. As you know, space is really limited. And then they wrote who was the media that was approved, which were 9 members. So they were told about that. This talked about protocols and courtroom decor and what they were going to be allowed to do. More media stuff. This talks about the overflow room being eliminated. Let's see here. This talks about the curfew. Collin County Sheriff's Office does not discuss security protocols, processes, or procedures. Okay. Yeah, you are going to be taking notes on pen and paper, old-fashioned. That was to Steve Stoller, Nikki. You'll be allowed to take notes with pen and paper. So Nikki is just pissed off and raising all kinds of hell. It talks about testimony. let's see. Sergeant Davis conversation regarding admission of the media and the public cell phone video transcript and authenticating affidavit. Okay. So, hey, I'm doing all right. Sergeant Davis with Collin County Sheriff's Office. Hey, is there a reason for you being here right here? Demetria Carter. I was waiting for because I know y'all gonna, so I don't know how y'all was gonna do it today. So I want to just follow however. Y'all gonna do it to get in the courthouse. Sergeant Davis, okay, you would have to follow the same thing what we tell everybody else. You can park anywhere else, but you cannot sit. This is a construction yeah. Demetria Carter. Okay. Sergeant Davis, because Demetria, so just go down there to the church. How was Sergeant Davis? Sir? You can go to the church. You can go. I mean, it's up to the church to call on Demetria. So are y'all letting media in like y'all did yesterday? Sergeant Davis said media is allowed at 4:30 only with their proof of media license. Demetria Carter, yeah. Because yesterday they had people that wasn't the media in there. Yes, were. Sergeant Davis trying to fix that. Demetria, thank you so much. Because Davis said, but it is really hard to Demetria determine. I was there at 4. I was here at 4:30. And I'm the first person in line. And I go in and it's already a 23. Yeah, we're trying to. 27 people in the public line. Yeah. So I'm like, oh my God. Okay. I understand. And it's really hard for us to determine who's what. And people print out whatever they want and make themselves like they're media. It's hard for us to determine. Right. But I would recommend either the church there's also Life Path there. And then we come up at the 5:36. Sergeant Davis at 6. 6 is when they allow civilians to come in, non-media people. However, like I said, it's really hard. You can circle back and kind of keep driving up and down and see what's going on, but we are only allowing media at 4:30 because they come on at 5. Right. They have to get in there and set up their cameras or no, they don't have to set up their cameras. Maybe they're just reporting. Who knows? Team Mutual, whatever. Because I just noticed like 27 people in public line. Yes. And I was the first one in the gate. And I'm like, so how'd they, right. So they must have came in as media. Sergeant Davis, I'm assuming so. I don't know. I wasn't there yesterday. Demetria, but today y'all checking badges. Sergeant Davis, they should be. I don't know. That is what we're told. We're supposed to check for media, and it's hard for us to even check badges. Sometimes they'll show us just cameras, and that's what we have to go with. I don't know. It's hard to determine. Well, that shouldn't be a good thing, Demetria, because if that's the case, I'm an independent journalist because I report on my channel and my stuff. Yeah, that's including the independent journalism, right? Like your TikTok and all that. No, that's not what we're allowing in. We're doing just media, not like, yeah. So, because I've seen a couple of them, not saying that you're not important. That's not, a couple of them in there are independent and they got in first. Yeah, I'm not sure how that's all happening, but I know for sure we are trying to keep people out until 6 a.m. Even media, we're trying to do that, but some of them have gotten approval. Okay. I don't know how. I don't know from what. From what I know, 4:30 is media only. 6 a.m. is what you call it. Rest of civilians. Why is this? Sergeant? That's not how you spell sergeant either. But okay. Demetria. I'm gonna be me and a white car that just drove off. We gonna be the first ones. And I'm hoping that there don't be a line because yesterday I was like, how they even get in. Yeah, so I'm guessing we're trying to hold off people leaving, lining up. That's our biggest issue, okay? Because we're lining up at 6 8 because they were lining up before 6 a.m. That's what happened. Right. So we're gonna keep them off at 6 and you guys get there. See, that's the point. That's what we're shooting for. Like everybody remain in the car until 6 and we can run up there and see who gets there first, but hopefully nobody gets trampled over, right? Yeah, no pushing, no shoving. We're not going to do that cuz yeah, let's hope not, right? But yes, I would recommend hey, going up, yeah. That window don't go down. You're fine, wreck anywhere else. If you need to drive up and down periodically, by all means. I'll stay back there. Okay. Yes, ma'am. 6 a.m. is when it's supposed to be, but I don't know again. I'm just following the rules. She said fine. Okay, so they got me lining up doing the same thing that they claim that we did yesterday. The same thing. So I'm hoping I get in. I was a white Jeep that I was parked in Kylie Jenner parking lot like me, but y'all heard what she said. What? What Kylie Jenner parking lot? So now today supposed to be no lining up until 6. So I'm gonna go up where around maybe 5:30 and I'm gonna go ask her. So where are we lining up? Are we lining up in the courthouse or little walkway like we did yesterday? If it's the walkway, I'm gonna shoot there as fast as I can. I'm gonna try to run real fast. I'm sure I can run faster than some people, I'm sure. I'm hoping, I'm hopeful. So, and I'm gonna try to be one of the first ones in the parking lot so I can get the closest parking. So, yeah, we'll see. Okay. Like what in the Ebonics? What in the Ebonics? I didn't even understand most of that. So, oh, that's why. She recorded this conversation on her cellular device. The video file was identified as this, and a true and accurate of the recording of that conversation. It has not been altered, edited, or modified in any way. A copy of the recording is filed conventionally with the clerk. Yeah, that's why things are misspelt in there because she can't spell sergeant. All right. So that recording has been submitted. I wish we had that and I didn't have to just read whatever that was. Affidavit of Mike Howard, which is the trial counsel. Of course, he's over 18 years of age, sound mind, competent and qualified to make this affidavit. Personal knowledge of the facts here within. All right, let me see what else we have here because I may just have to do this in a separate video. What is this one? Okay, that's more affidavits. 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 Okay, that's the email that we've already looked at. Jury instructions. We went over the jury instructions in a previous video. Verdict sheet. Affidavit. And then e-service. Okay. So we'll stop there for today, and then we'll start on the affidavits next time. And I may just all right, so we're at 135. So we will start with the affidavits of everybody next. So there will be a third part to this. And we'll continue to see what everybody says because I want to look at all sides. I'm interested to see some of the things that are going to come of this. What opinion or something might be done. This is going to be denied, period. So, but it just gives us a view of what they're going to be arguing when they do their actual appeal, which they have to wait till the transcripts are available. So we shall see. But everybody have a good night, day, weekend, whenever you're watching. And I will see you in future videos.